Good afternoon to everyone. Those of you that might be a little bit tired of hearing my name, again, my name is José Antonio Rivas, and I do this just for purposes of making sure that the video recording and for those that are joining us online know sort of the proceedings and know the name to the face. Not to bore you, but again, my name is José Antonio Rivas, and with Ian Laird, we're co-founders of the World Arbitration Update globally, and also we have an incredible collaborators and partners in putting this together, including Reza and Yannick and also Martin Doe, as well as other collaborators and an executive team, making sure that this is something that goes well. So thank you again to those that are in Washington, D.C. and in Colombia, making these proceedings a reality. Now, having said that, I would like to refer to this panel, which is finally what ultimately in some arbitration cases, that's what funders would tell you, what matters, which is quantum. It's ultimately what matters if full reparation cannot be achieved through restitution, then compensation comes in. We have an incredible set of experts, an incredible presenter, moderator, and my task is only to present the moderator. But before that, I would like to emphasize why this topic. I mean, beyond making a structure very close to an investment treaty and very close to an actual investment arbitration proceeding, quantum at last. But beyond that, there's also something that I found actually impressive in the advisory opinion, which is the advisory opinion, and I cannot give you the paragraph, I've written about it, but I don't have the paragraph in mind now, did something that before it was put into doubt as to whether or not the lack of compliance with the greenhouse emissions commitment and on the reduction of the temperature was something that could be assessed and in terms of the contribution of individual countries. And before the advisory opinion, that was put into doubt. And actually, within the advisory opinion, based on scientific evidence, what at least the advisory, what the ICJ found was that there can be an assessment of how lack of compliance with NDCs could lead to assessing how that particular state that did not comply contributed to the increase of the temperature. So I found that remarkable, because from there you can actually trace it to an issue of harm. What was the harm that was done, and you can find a causal link between the omission and the harm, and ultimately the quantum. I'm not a scientist, and I've never been an expert on quantum, but that is something that I found remarkable, because it does move forward the issue. That's why we're here. With that, it is with incredible pleasure to present our moderator, Professor André Nollkamper, who is a distinguished university professor of international law and sustainability at the University of Amsterdam, where he also leads the interdisciplinary climate change institute called 7, with capital letters. He is member of the Institut de Droit International, former president of the European Society for International Law, and former external legal advisory of the Ministry for Foreign Affairs of the Netherlands. He writes and advises regularly on questions of international law and climate change, particularly in relation to the international responsibility of states, of corporations. Professor, thank you, and you have the floor.
Thank you very much. It's a great pleasure to moderate this panel. And let me, just to frame what you will be listening to, highlight the key terms that were put in the abstract for this panel. So what we indeed will do is to examine how damages are assessed in climate-related disputes in the light of the advisory opinion. So we will be looking at the methodologies used to quantify climate-related harm, questions of stranded assets, future profits, and what this means in terms of evidence and valuation. And we are also tasked with discussing how the ICJ's articulation of obligations may influence causation, attribution, and quantum. So these are huge issues. So listening to the previous panels, they are all sort of staying at a general level, complex enough, but still general. But now we're going to take a deep dive into the technicalities of evaluation and quantum. We have an excellent panel to do this. We start, as with the other panels, with a presentation by Miguel Nakhle. Miguel will speak for about 7-9 minutes to frame the issue. Miguel is the Executive Vice President at Compass Lexecon in Houston, Texas. Has a long experience, 20 years in economic and finance consulting, been involved in over 50 arbitrations under various arbitration rules, and routinely testifies on questions of damages and regulatory issues. So Miguel, over to you to frame the topics before us.
Thank you, André. And thank you, World Arbitration Update, for the invitation to this conference. It's great to be here to discuss the ICJ advisory opinion, and a very important document. It is so important that if, in case you here in the room have not noticed, there is a signed copy with wax seal and all in a glass box downstairs. Right before you exit this beautiful building, take a look for it. It's right there, so go ahead and take a selfie with it before you leave. As a way of context, let me start by simply reiterating in the next slide, please, the two questions that were posed to the court that we already discussed in prior panels on the obligations of states to ensure protection of the climate system and other parts of the environment. The court unanimously stated that it is of the opinion that climate change treaties set forth binding obligations for states to ensure the protection of the climate system and other parts of the environment. And not complying with those obligations, the court said, has consequences for states. So if we go to the next slide, on the consequences, there's a duty of performance. That means that even if there is a breach of these obligations, the court said that states ought to continue to perform with their obligations, which means that just because there is a breach, it doesn't mean that states are free not to comply with them. And also there's a duty of cessation and guarantees of non-repetition. Whatever you are doing, stop doing it and implement measures to reduce greenhouse gas emissions and ensure compliance. And finally, the duty to make reparation. So if there is harm, a responsible state has the obligation to make full reparation for the damage caused by the internationally wrongful act. And then in the next slide, talking briefly about the duty of performance and cessation, this is where it gets interesting for us in particular. The court said various things. This can be claimed also by non-injured states, irrespective of the existence of harm. And more generally, and this was discussed in prior panels, but I will reiterate that the court concluded that states have an obligation to regulate activities of private actors as a matter of due diligence. So here is, when we think about investor-state arbitration, the regulatory chill that was mentioned in the prior panel, the idea that the threat of investor claims would deter states from enacting ambitious climate regulation. The court says that states have a duty to regulate, and this has led, as we see, these regulations on climate change to investor-state disputes like the RWE Uniper case mentioned before. So when we think about damages, this is already telling us that we need to account for the fact, and this is not only for experts, but even mostly for counsel, whether the ICJ opinion will reframe the legitimate expectations discussion. Julia mentioned in the last panel, can an investor who, after July 2025, let's say, acquires a long-term fossil fuel asset, let's say a coal-fired power plant, can they reasonably claim that it didn't expect changes to regulations? And more importantly, what kind of changes to regulations? From a quantum perspective, the question of future lost profits, stranded assets becomes very relevant. We are always advocating for forward-looking valuation methods. We are always talking about the DCF approach, and we will talk about it today. Should we incorporate regulatory risk? And regulatory risk of what exactly? What are we expecting? What should a reasonable investor expect a state would do? This panel will explore that. And then another point that both Mayre and Jose Antonio raised in the last panel is that we tend to think about investors in fossil fuels and other polluting technologies being affected negatively by the ICJ opinion. But what about investors that can use the ICJ opinion to support their claims? It was mentioned renewable energy investors that can claim that a certain policy that impacts them is against the state's obligations in relation to climate change. And then the reality of what we see in our practice. And just as an example to give you of arbitrations that I have personally been involved in, involving African governments and mining cases, when we think about, for example, a gold mine operator that would like to install a solar power plant to lower their cost of production in the mine, to lower their energy cost in the mine, the government is not approving those installation of solar panels. Why? Because if you don't use solar panels, you have to use diesel and fuel oil, which are imported and which pay import duties. So they represent a source of income for the government that the government would not have if solar panels are installed to replace that or to lower that consumption. So here you can already see the tension of something that would in principle be good for the environment, in line with the obligations, but of course there's also incentives for all parties involved. So this panel, particularly Kenneth and Lukas, will deal with these issues. And then if we go to the next slide, we'll talk about the duty to make reparation. And here, the ICJ opinion for all the economists involved lands with this very familiar territory for us, which is the Chorso dictum that reparation must wipe out all consequences of the illegal act and reestablish a situation which would, in all probability, have existed if the act had not been committed. And the court says this can be done through restitution, compensation, or satisfaction. But before we get to that, the opinion says, and we know, and we're glad that it talks about it because it's always so important, that we need to establish causation. So in the next slide, we'll talk about that briefly. The opinion says causation needs to be established. It's not impossible to establish and should not be presumed. And it describes that, that causation is this legal concept that plays a role in determining reparation, that many participants have argued that causation is impossible to establish, they say, in the present context due to the diffuse nature of climate change. Other participants have taken the other extreme view and say, well, causation between a wrongful act and damage should be presumed in the context of climate change. But the court finds that neither of these positions is convincing and concludes that the standard of a sufficiently direct and certain causal nexus is flexible enough to be applied in this context. So for us practitioners, when assessing damages, this means creating a robust but-for scenario, the counterfactual based on scientific attribution methodology, as Jose Antonio mentioned, on a case-by-case basis. But causation needs to be established. And finally, when talking about one of the three ways, in the next slide, please, of reparation, which is the one that we like the most to talk about, which is compensation. Compensation defined by the ICJ as the financially accessible damage suffered by injured states or its nationals, to the extent that its causal nexus can be shown. Unfortunately, the court doesn't elaborate much more on that. It does confirm that environmental damage is compensable under international law, which may include indemnification for the impairment or loss of environmental goods or services, and the expenses incurred by injured states as a consequence. It does leave the door open for global sums based on equitable considerations, but says that that's only in exceptional circumstances, and concludes by essentially throwing giving us the duty to try to come up with a way to assess this, because it says, recognizes that compensation in the context of climate change may be difficult to calculate, as there is usually a degree of uncertainty. So fortunately for us in this panel, and for you actually in this panel, we will explore this topic as well with the guidance of very good experts like Fabricio and Veronica, who will deal with these methods. Thank you.
Thank you very much, Miguel, for the broad laying out of the themes for today. We indeed have four excellent speakers whose presentations are sort of interconnected. So I ask you to bear with us, and we have first the four presentations, and then we open up for discussions, because they're so connected, it will be difficult to handle each of them apart. So we start with Kenneth Figueroa. Kenneth is partner at Foley Hoag, where he's chair of the Latin America practice on litigation and arbitration, with extensive practice in dispute settlement, investor-state and state-to-state, and in particular, a practice relating to the damage assessment and calculation for defense and as experts. Kenneth, over to you.
Thank you, André. Thanks very much for all being here, staying with us till the very end. We know that damages at the end is not usually the most popular subject, even before tribunals, so we appreciate your attendance. Also, let me quickly thank Jose Antonio, Ian, for the invitation, all the organizers at World Arbitration Update. It's a real privilege to be here at this incredible space, and definitely a privilege to be here on this panel with such esteemed colleagues. So I'm going to focus on investment arbitration, because I feel that it's in my opinion, this forum has been kind of the most challenging forum in which state obligations with respect to the environment have been able to be placed into effect because of different interpretive challenges and decisions from tribunals that tend to limit those obligations, and I'll get a little bit into that. And that's had an effect also on damages calculations. I think that's important to realize some of the shortcomings in investment arbitration, so we can see how the ICJ advisory opinion might, I hope, positively impact analysis of damages going forward. So I start with reminding everyone that these environmental obligations are not new. Right? We have the UN Framework Convention signed in 1992, Kyoto Protocol in 1997. The Paris Climate Agreement is 10 years old, back in 2016. So these obligations have existed for decades, and they have been fundamental, and they've been so fundamental that states, in fact, in their new generations of treaty have included express carve-outs to address these environmental regulations, which states knew they would have to implement consistent with these international obligations. Unfortunately, though, investment arbitrators have tended not to give those carve-outs the weight that I believe they're due. And one quick example that we can give is Eco Oro v. Colombia. Now, that ended up being in favor of the state when it got to damages. But the state still had to defend itself over the claim in spite of its jurisdictional objection based on an express carve-out in the treaty. And the tribunal essentially took note of that carve-out, but indicated that essentially reflected a truism, that is, that the state has the right to regulate when it comes to the environment. But that doesn't mean that it precludes liability, responsibility, or damages to the extent damages are proven. Now, part of that is certainly true, but I think really that decision gutted the intention and the state's intentions in implementing these carve-outs in the treaties, which is to say that to the extent there are issues with regulation, it would not be decided in ISDS fora. It would be decided perhaps in national courts or in other areas, but clearly a carve-out was meant to carve out those types of regulations. So these kind of limitations also see themselves play out in the case of damages. And a case here we've discussed a lot, and I've seen in other panels, in the Rockcopper v. Italy. All right. Now, I won't go into the details of it, but essentially, Italy had adopted an offshore ban, a ban on offshore drilling within 12 nautical miles of its shores. The claim here, the tribunal once again gave, I would argue, lip service to a sovereign's right to regulate with respect to the environment. It recognized that it was a right. But like in the Eco-Auto case, they said that didn't preclude potential responsibility and payment of damages. Now, what they did with and so we see some shades of Eco-Auto, which we see in other decisions, unfortunately. What they did with damages was particularly interesting in that it rejected all of the damages valuations presented before it. It rejected claimants' DCF analysis, stating that it was too speculative. The project had never gotten to a start. In fact, all they had was environmental impact assessment, and so that was the basis of their claim. So there was no ongoing operations. It also rejected Italy's alternative valuations based on a market comparables approach and a sunk cost approach, stating that undervalued the investment because some activity had taken place that differentiated from a true startup. The tribunal essentially what they did then is they took a DCF model that was in the record, that was not relied upon for damages, but essentially the model was the model prepared by the investor when it acquired the company that had the initial rights to submit the environmental impact assessment. And based on this DCF model, it awarded $184 million plus decommissioning costs. So there's several problems here I want to address with respect to that. First, there's a burden of proof problem, which I think is broader than just an environmental issue. But here, you know, and we can get into a debate about this, a more general debate. But if a tribunal rejects every single valuation presented before it, one would think that the decision should be no damages, instead of sua sponte coming up with another basis to come up with some measure. This isn't the case where they believed of some valuation, but there was some tinkering they needed to do. They rejected all the valuations, either as speculative or undervaluing. And here, as a comparison, Eco-Auto, at least that tribunal got it right on damages. Eco-Auto eventually determined that what could be awarded was a lost opportunity for the concession. But because claimant hadn't presented a lost opportunity valuation, there were no damages. So at least in that respect, I think that they were right. So that's the first issue. The other problem is the general issue of whether DCF is appropriate in these kind of startup companies that are not ongoing. But the major issue, and the one that gets to the heart of our debate here, is the model that it used clearly had a purpose, which was a commercial purpose to acquire a company. It did not involve all the issues that that should be resolved in investment arbitration. In this case, when you're talking about climate regulation, a valuation should take into account things like contributory negligence, assumption of risk, potential costs for mitigation, potential increased costs related to foreseeable regulation in certain sectors, and transition exposure and transition risk, which can be priced out either in the cash flows or in the DCF model through the discount rate. None of those, of course, were in this commercial DCF because it wasn't an issue. It wasn't contemplated for commercial purposes. And that's generally the problem that we have with valuation in the environment, valuation in cases that involve environmental regulation. You know, we see how perhaps valuation should occur in the case RWE v. Netherlands. Now, as had been discussed before, that case was ultimately discontinued. Netherlands obtained an anti-arbitration declaration from the German courts, and ultimately the Dutch court, I think, properly took into account the foreseeability of regulations and the long term for its phase out, and claimed that and decided that the measures were proportional. And I think that should be, and one hopes that with the ICG advisor opinion, arbitral tribunals will follow suit in terms of that analysis. But what's interesting about that case is actually in the arbitration, there was a damages report actually prepared by Compass Lexecon, which was very good, and which takes into account and discusses these types of transition risks and costs which should be taken into account when evaluating damages involving regulatory environmental regulations. And so that's what should be taken into account here. We'll see what happens. There's a case AETV Germany, which has also been discussed. There, Germany has objected to claimant's DCF valuation, saying it's flawed because it fails to use Paris Agreement compliant inputs, and particularly the cost of CO2 certificates and development plans required by law that incorporate renewables expansion. None of those costs are incorporated in this valuation, and therefore it's defective. So we hope that there's a change here. Here, Philip Sand's dissent in Odyssey Marine versus Mexico is informative. There, he claimed that, pursuant to the Vienna Convention, we've seen some of the discussion in other panels, it requires an interpretation of investment treaties to take into account all relevant rules of international law, which includes laws under customary international law, particularly with respect to the environment. And so he was talking about liability here and responsibility, but it also applies to damages. And so I hope that with the ICG advisory opinion, there's a clearer picture in which tribunals will more carefully look at carve-outs, for example, will more carefully look at contributory negligence and mitigation, and in the assessment of damages. So I'll pause there, and hopefully we can have a richer discussion later on. Thanks.
Wonderful, Kenneth. Thanks very much for laying this out. I think we can move immediately to Veronica Irastorza, whose presentation will nicely build on this. Veronica has been a long-time expert on damages estimation and energy, produced written and oral testimony in a variety of cases, and before that was Undersecretary of Energy Planning and Transition of Mexico and head of planning of Pemex Gas, the national gas company. So Veronica, listening to Kenneth and knowing what you've been working on, so maybe two things come to my mind. So can you talk a bit about the most important precedents in this area? So which cases can we actually rely on to shape our thinking in terms of what methods, evaluation and damage may work? And maybe you can also speak a bit about the methodological challenges and perhaps errors that have been made.
Great, thank you. Thank you, Ian and Jose Antonio, for the invitation. This is the first time that I'm here, so I'm very excited to be here at the Palace. In terms of precedents, I think there haven't been many arbitrations that go to quantify the damages in climate change or even environmental cases, but there have been a couple. I want to start, though, talking about the experience quantifying damages in litigation, because there's much more experience there, particularly in the US. And one case that came to mind was the Oregon versus Monsanto case that ended up settling, but it was very, very relevant. And the damages awarded, well, not damages awarded, but the settlement ended up being around $700 million. And to come up with that calculation, there was a detailed study by scientists to really assess what the damages were of these chemicals on the environment. And they saw specifically how it affected the specific species that were there, for example, the whales, and what would it take to restore to the original, to how it was without these chemicals, right? And of course, to quantify the damages, you cannot say, okay, we have 100 less whales, let's go to the market and buy them and put them back in here, right? So really, the scientific evidence and the scientific knowledge was really important to say, okay, what would these whales need to thrive and to go back to get that population back to how it was before? So they came up with this analysis and specific measures, and then that's how they quantified the damages. And my understanding is that then after the settlement came, that money was used to restore the environment, right? And I also think that there's an important distinction in environmental cases that we have to keep in mind. And there is a difference between remediation that is often used, and remediation focuses only on removing whatever the contaminant is, or neutralizing it. But it has nothing to do to how this area was before the breach or before the contaminant, right? So it's just, okay, let's remove this, make it safe, but it doesn't have to go back to how it was originally. Maybe it will look completely different, but that doesn't matter. And then if we go to the full restoration, that does mean taking everything back to how it was, not just removing the contaminant, but bringing, like, again, here in the Monsanto case, it's not only removing these pollutants, but it means bringing back the wells to Oregon, right? So it's these two very different approaches to damages. And in terms of arbitration, this case was mentioned before, but the Ecuador oil cases are very instructive. There were two connected arbitrations arising from oil extraction, where then the state counterclaimed with an environmental damage, and they were awarded damages in both cases. It was very, very complex and long arbitration, and Ecuador, when it quantified the damages, they wanted full restoration to pristine conditions, right? Ecuador's experts used this standard to arrive at a 2.5 billion claim in remediation costs. Perenco, the company, said that the law prescribed a specific regulatory threshold criteria for permitted oil field activities, and that only anything that exceeded those limits would have to be compensable. So it was two very different scenarios that, of course, reached very different valuations. And Perenco's valuation was 10 million only. So what happened is that the tribunal ended up appointing its own independent expert. And this expert did a supplemental work, like reviewing the other experts, but also doing his own to measure the total contamination in those oil blocks specifically. And here it was a valuation where he came up with a number of 160 million figure for total contamination across both blocks. But that contamination could be from that company or companies that operated there before or after. So the tribunal after that had to allocate that to the different companies that were involved. So that's how the damages were calculated, but after, as I say, after a very, very long and complex arbitration. And you asked me also about the methodology. And here I want to explain why, on top of that, there are important challenges. You know, often experts just jump to calculate or estimate damages before they have determined clearly what they are estimating. So it's not just about the process, but it really can affect the outcomes. What I mean is specifying the counterfactual or the but-for that we need when we quantify damages. How the world would have been without that harmful activity. And in some of the cases that I have done and I have read about, these counterfactuals can be straightforward. It can be, what would this business have earned without the harm, or if the contract would have continued? And it can be pretty direct, right? The but-for and to calculate the damages. But now for climate change, think about what it means to ask, what would this ecosystem look like today if a particular country had not emitted its share of greenhouse gas? Then it's a much challenging counterfactual to determine. And the standard valuation tools that we use were designed to quantify uncertainty, to put a range about an answer that exists but can be hard to measure. They are not designed for cases where the outcome itself cannot be specified. Like an old growth forest destroyed over decades it's a clear example. The counterfactual is not a forest with an uncertain species mix. It's a centuries-long ecological trajectory that was interrupted. So you would need really good scientific experts to assess the damages in these cases. And of course, applying a cost of restoration model in that settling will produce a precise number that is not really accurate, right? When you see damages go to the cents when you're trying to specify something like this is very speculative. So we need to first define the counterfactual precisely, and then establish whether we can get the available scientific and economic data to, after that, determine the technique that we will use to estimate. Environmental economics have already done a lot of this work, and we have the right tools. They know how the ecosystem services can be evaluated, the natural capital accounting, etc. And the problem is not the tools, it is the order in which they are applied. Getting the sequence right does not narrow the range of damages. It makes the basis for that range transparent and contestable, which is the minimum condition for any number to be scientifically defensible before a tribunal. So we will need really good science to quantify damages, and also good economists that are careful to do this hard work.
Thank you, Veronica, for laying out some of these complexities. Fabricio, we'll continue on this line. Fabricio Nunez, Managing Director in NERA's International Arbitration Practice, with a widespread experience in consulting in the corporate sector, and provided expert testimony on valuation and related topics before the ICSID, PCA, and ICC in a variety of arbitrations. So Fabricio, can you talk a bit more about your framing of the damages questions in climate-related disputes?
Thank you, André, and thank you to the organizers for the invitation. It's good to be back in this building. I haven't been here since 2022, so I really like to be here. Let me start with one simple but perhaps an obvious point, that climate-related disputes are not all the same. They do sit within the broader transition to clean energy, and what that means is that they raise different kinds of damages question. So for me, the most useful way to think about them is not to look for one magic formula or one size fits all approach. I like to think about in terms of typology, types of disputes that share some economic questions, economic logic, but that they all have the same theme that Veronica mentioned that cut across all of them, and is that we should look for ways to remove the breach, not the transition. To me, that's the anchor. And the economist's job, of course, is to not recreate a world in which there's no decarbonization or no climate regulation or no carbon pricing or ESG pressures. Instead, the job as economists is to isolate the effect of challenge measures in a world where these other forces are already in operation. That's why the ICG opinion is also important, not because it gives us a damages formula, it does not, but because it redefines the baseline. It becomes much harder to say that climate obligations, transition risk, and regulatory changes somehow sit outside of the counterfactual world. So in terms of types of disputes, the first one is the fossil fuel and legacy assets. That's familiar to all of us. We have talked about this today. Coal phase-outs, drilling restrictions, accelerated closures. That's where most of the existing investor cases sit. Then the central question is relatively clear. What part of the loss was caused by the challenge measure, and what part was already embedded in the value of an asset in the context of transition risk? And that's where the counterfactual discipline really matters. If the bad fall assumes unchanged carbon cost, similar utilizations, or not tightening of climate policy, whatever we model is not just removing the bridge, it's removing the transition itself. The problem is not in the spreadsheet, the problem is in the framing. And this is what I think is important from cases, some of the cases that Kenneth spoke about. And sure, there will be some debate about the appropriate valuation approach, what is the most useful valuation method that we could apply, but in some ways that question is downstream of the key question that the tribunals tend to be skeptical about something because they don't believe that the model that the economists have put forward, the experts have put forward, is credible and consistent with the transition context. There's a second type of dispute that I like to think about, which is the climate-related financial disclosures. So why do I mention them in the context of investor-state disputes? I think they matter because some losses are not really about physical impairments at all. They're about how climate risk is priced, disclosed, and transmitted through financial markets. There, the task in those cases is to separate loss tied to a specific act or omission from broader market repricing. This is where some of the securities-type litigation methods might be useful, like event studies, not because every case becomes a security case, but because the logic imposes some discipline to separate some company-specific effects from market-wide movements. A related type of dispute has to do with carbon markets and environmental attributes. Allowance, credits, certificates, similar tradable rights. Here, what is interesting about these cases is that the asset was market-based or market-created from the beginning. And when that's true, the best evidence might not be a long-range DCF model, not because it's not useful, but because we might have other better available information for market evidence, spot prices, auction data, forward curves, trading data. So the question becomes, did the Challenge Act destroy the value of a particular instrument, or was the movement of value simply a reflection of the normal evolution of the framework that the system already created, itself created? Then there's another category of damages on critical minerals and green supply chains that Kenneth spoke about in a few of them. These projects are often described as strategic, essential, transition enabling, and that might be true, but economically that does not make them easier. In some ways they make them harder. Why? Because these projects are often early stage, uncertain, highly dependent on social license. Again, it's not the method that matters, it's the framing of what we're trying to prove. That's exactly the cases, as an economist, the kinds of things that come to mind when I think about cases like Odyssey Marine, South American Silver, Bear Creek, Eco Oro, and why they're informative for climate changes. The recurrent difficulty in those cases, and that can potentially apply to climate-related disputes, is that those projects are too early, too uncertain, very contingent. So anything that we do with future cash flow evaluation is not per se bad, it's just difficult. And even if the tribunal find liability, we might still conclude that recoverable damages have not been established. For me, the question, the important point there is the social license is no longer a background in the context, it's part of the economics. We have seen this concept, but it takes a more prominent role in light of the ICJ opinion. It goes directly to whether a project can realistically move through permitting, financing, construction, and operation. And when you see it that way, there are three familiar issues that we're all familiar with come to the center of climate-related disputes: mitigation, contributory fault, ESG-related evidence. And as economists, we have to help tribunals to understand whether the investor could have redesigned a project, face it differently, or engage more effectively to reduce the loss. What strategies? Economic strategies. Did the investor underestimate obvious community, environmental, or stakeholder risks? And what did the investor themselves told the market, the regulators, the communities about these risks? The other reason that these cases are interesting is that here's where some of the methods that Veronica was speaking about might come into play. Methods that in arbitration they're not very common, they're not very widely used. methods like economic impact analysis, contingent valuation, non-market methods, social cost-benefit analysis enter the picture. I don't think that necessarily as replacements for individual or for traditional valuation, but as part of a wider evidentiary record, because the dispute itself is broader. And that brings me to the last type of dispute in which, if I have to game it, this is where I see the frontier. This is climate, tort, human rights, and strategic policy disputes. These are not, of course, classic investor-state disputes, but they matter enormously for the future of climate-related quantum. And they matter for two reasons. First, because this is where the most interesting methods are likely to develop. Veronica spoke about those. Attribution-informed modeling, as mentioned already, economic impact analysis, social cost-benefit analysis. And those are methods that in environmental economics, in some litigation in the US in particular, we're familiar with those. But they take a different framing to bring them into these kinds of disputes in the climate-related arbitrations. And the second reason that these final type of disputes are important is because they reshape the baseline for everything else. They can broaden the evidence and change what counts as a realistic background world, especially in defenses and counterclaims and state-state settings, which some other panelists have spoken about. So in closing, to me, climate-related quantum is not homogeneous and is not amenable to one method. Different disputes raise different economic problems, but the discipline remains the same. We cannot lose focus. The North Star that guides our work as experts has guided our work as experts forever, which is identify a credible baseline, isolate the loss caused by the breach, and use the method that fits the asset and the dispute. In the end, full reparation cannot be an insurance against the transition itself, and we have to keep that in mind. Thank you.
Thanks, Fabricio. It's a very nice closing sentence that we may get back to. But before doing so, we have Lukas. Lukas Schaugg is the final expert on the panel, policy advisor at the International Institute for Sustainable Development, where Lukas has worked on reform of international investment governance in the nexus with climate and energy. And in that capacity has advised various governments and regional organizations. So I guess, Lukas, this takes a bit of a broader perspective on the role of valuation in investor, state, or generally investment governance. Please.
Thank you, André, and thank you also to the conveners for the privilege of participating in this last panel of the day, especially at such an august and impressive location. The International Institute for Sustainable Development follows the question of the assessment of damages closely, both as an observer at UNCITRAL Working Group 3 and also through a sustained research program on valuation, compensation, and the fiscal exposure of states. My fellow panelists have already covered the leading cases and the valuation methods, so I will not revisit those. But as the final speaker and also a think tank representative, I want to step back to the systemic and policy level, but also to confine myself to one specific setting, namely investor-state arbitration, as it specifically bears on disputes related to the phase-out of fossil fuel investments across the value chain, from upstream extraction through to downstream consumption. So my focus is somewhat narrower than that of my fellow panelists, but at the same time at a higher level. My central submission is the following. The hardest questions, in my view, in these types of disputes will often not lie in the economic valuation methods themselves, but rather in what has been called the mid-level legal principles that already govern and constrain those methods, and in the weight that investment law generally attaches to investor expectations. The mid-level legal principles that connect the existence of a breach with the quantum of the award, namely the scope of compensable loss, the causation as a question not only of fact but also of law, and the standard of proof are not aspirational issues. They are established constraints, and tribunals, in my view, have too often failed to engage properly with these mid-level principles, instead deferring relatively swiftly to the economic expertise of valuation experts. Many international courts rely, and we've heard this, on the full reparation standard in torso factory, so not only investor-state arbitration tribunals, but it is investment tribunals that have applied this standard far more expensively than their peers. The ICJ, the IUSCT, the United Nations Compensation Commission, and the regional human rights courts have all been markedly more cautious about this. These other courts typically, for instance, decline to compensate the loss of hypothetical future earnings where such loss cannot be established or proven with a high degree of certainty. And in such cases, these other courts typically award lump sums that are confined to equity infra legem. So on the recent literature, it would seem that it is investor-state arbitration tribunals and not the practice of these other courts that are the outlier here. This matters, in my view, because the method that now dominates in ISDS, discounted cash flow, can obscure prior legal questions about the legitimacy and the permanence of future income generated from fossil fuel investments. It's granted the advisory opinion does not say or says little about quantum directly, but, and this has been mentioned by my fellow panelists, it bears on what counts as the counterfactual for full reparation. The court says states have a due diligence obligation to regulate private actors, and that continued fossil fuel production, including the granting of new exploration and production licenses, may amount to an internationally wrongful act. As states' climate obligations harden in this way, we must ask ourselves how far an expectation of full life cycle production can still serve as a secure baseline for measuring loss. And I would like to make 3 further observations to emphasize these concerns, especially from a policy perspective. First, in contrast to earlier investor-state arbitrations, income-based methods now feature in roughly 44% of recent awards, while cost-based approaches that were much more prevalent before have fallen to around 14%. These forward-looking valuation methods often rest on the premise of a hypothetical market. The evidence may support only with a highly optimist turn of events. Second, the literature on large projects shows that around 90% run over budget or over schedule, and fewer than 1 in 100 of these projects deliver on cost, time, and benefit together. And third, the DCF method in particular produces vastly differing estimates in and of itself. So in the case of Rockhopper versus Italy, and it has been cited by Kenneth already, the same method actually produced a range from 68 million to over 1.5 billion euros, a spread of some 2,200%, driven entirely by contested inputs. So I want to add also one point the visible caseload cannot always capture. It has been mentioned in previous panels as well, and that is the issue of regulatory chill. Regulatory chill is the phenomenon whereby a state that is anticipating the risk and cost of a claim refrains from adopting or delays a measure it would otherwise have taken. Among all aspects of an investor-state arbitration, it is, of course, the expected quantum, so that's where our panel comes in, or the unpredictability of that quantum, that is the main lever of deterrence for that state. So that is why valuation is not a narrow technical matter. It is also a question, a policy question and a regulatory question of how far states remain free to govern de facto in the public interest. So if tribunals are not only paying lip service, but going further than this, we might ask ourselves, how does this constrain de facto the capacity of a state to govern in the public interest? I would like to close with 4 recommendations. As think tank representative, we tend to do these types of recommendations at the end of a presentation. First, in my view, tribunals should correctly apply the mid-level principles that already govern valuation. A demanding standard of proof, a rigorous test of legal causation, a disciplined definition of compensable loss. This is the starting point. Second, in my view, the general principle against unjust enrichment should operate as an upper limit on compensation in phase-out related disputes. Third, I would specifically commend the proposal that was advanced by the governments of Vietnam and Nigeria in Answer Trial Working Group 3, which would require clear and convincing evidence. It would exclude speculative damages. It would confine income-based methods to genuine going concerns, because some of the projects that are in question at the moment, we see the Woodhouse investment claim against the UK, are very early stage projects. So the question is, should the value of the non-extracted coal even enter into the calculation here? The proposal would also limit recovery to a reasonable rate of return without windfalls, and oblige tribunals to weigh equitable considerations and the potentially crippling effect, fiscal effect of an award. And finally, and most directly, and that also relates to the discussions at the OECD, I'm wondering whether the cleanest solution, especially after the advisory opinion, would not be to remove fossil fuel investments from treaty protection altogether. Especially after the advisory opinion, it seems anachronistic to continue to extend vast benefits of treaty-based investment protection to the very activities that states are under an obligation to transition away from. And thank you very much, and I'm looking forward to the discussion.
Thank you, Lukas. That last point certainly is a topic that would lend itself for a thorough discussion here. Okay, before heading over to the audience, I just want to ask Miguel, because you spoke first, if there's anything you want to reflect on having listened to the panel.
Yes, certainly. And I will come here to counter a little bit what I just heard from Lukas. May surprise nobody. My point being a little bit on the practitioner side, and it's a little bit more general on this criticism of forward-looking methods and discounted cash flow in particular. I think on the contrary, I think these kind of methods will allow us to be more transparent. So instead of, in my view, obscuring the profits from fossil fuels, for example, will make evident what constitutes the value of a particular asset. So if we are thinking about a claim on a coal plant, for example, and we can know where the profits that are claimed are coming from, where the value that is claimed is coming from, the DCF will show that, will make it evident. So I think in a way it helps the tribunal to decide what the proper counterfactual is and what the award is effectively compensating from. No? So I think thinking that income-based approach are always more based on optimistic projections, and that the cost-based approach is more appropriate. I think that generalization is not necessarily correct. I think on the other hand, a cost-based approach may end up resulting in a much bigger compensation because the investment may have been done, or the cost may have been incurred at the time in which these climate change obligations were not prevalent, and now the investment simply doesn't have any more value, and the tribunal may decide that that's okay and grant compensation on that front. So I think it's just the fact that we have seen vast difference in valuations shouldn't deter from the use of the methods themselves. I think it makes the tribunals aware of where the differences are coming from and may provide, as we have seen, liability decisions or decisions on to the experts, or instructions to the experts on what specific assumptions to take, and that will certainly reduce or narrow the gap between the claimed amounts.
All right, so we were originally scheduled to have this panel until 4:45, but we did start half an hour late. So that at least go on until 5 and maybe a bit more if there's good discussion. So I suggest to open up for discussion. Please state to whom you will address the question, but of course all panelists are free to jump in if they would enrich the answers. Let's collect maybe 2 or 3 per round. Yes, please.
Thank you, Ian. Hello, my name is Munia. I'm mostly counsel in investment arbitration and commercial arbitration. My question is for Kenneth, and I thought it was interesting that you mentioned Eco Oro, and particular to the fact that the investor did not specifically claim for lost profits, and therefore somewhat lost that claim. And I was thinking about 2 things. one, alternative claims for damages that are happening in the Spanish cases, the ECT cases, post-PV particularly, but you see it in REF, or REF versus Spain, where the investors are starting to claim their DCF, and then also the reasonable rate of return that was mentioned by Lukas briefly. And then what Miguel just said at the end made me think also about REF, or REF, where even if the investor doesn't engage in an alternative claim, wouldn't the tribunal be proactive in pushing the parties to explore, and that was done in that case, to produce further expertise. In this case, it was a reasonable rate of return, somewhat to guide the parties and the experts in exploring, more nuanced claims for damages, and I think also more precise at the same way. Just a solution for once, maybe.
Should I go ahead?
Let me see, maybe we can collect one or two more. I think there was a question here, right? Yes, let's take this one.
I'll pass the microphone over. Actually, I just had a question of interest, and this is more of a technical thing for our evaluators. We're talking about DCF. Country risk is always a big part of the calculation. In light of developments, I mean, has Damodaran looked at this? Has he factored this into the country risk? How does that fit into that? Is it part of even the calculation? Because clearly there's some risk here. We'll ask another question here.
So my name is Genevieve again, and I'm with Global Climate Resilience Intelligence Network, and I'm a subject matter expert in this space. And I worked alongside the asset managers and banks and insurers in the industry and seen all of the corruption. So I'm an insider that turned the opposite direction. Okay, so I just kind of want to give an overview as we're thinking about this. So first, it's really important to understand whether or not we believe that Scope 3 should have in fact been reported by the states, okay? And the reason being is because Scope 3 is typically 60 to 80% of carbon emissions, right? And how can you sit there and say that something causes mass harm, right, and people displacement and economic instability, right, and that 60 to 80% of that mass harm or economic instability was not material, okay? That's problematic. But so that's something that you just park and put behind, right? Next, there's, as we go after, one state goes after another state, potentially, if one state goes after the other state and doesn't consider all 15 categories of Scope 3, right, then the claim would be inadequate, potentially. And then another thing is, if the state goes after another state, okay, and doesn't go after, and this is the hard part, the asset managers, asset managers, banks, everything else that basically caused the harm, okay, then how potentially could that cause indirect harm to other parties? And so what I mean by that is if one state goes and sues another state, okay, underneath this obligation, and they somehow, there's corrupt attorney generals in that state, right? So the corrupt attorney general, knows that potentially whatever the outcome is, whatever the cost, right, that the state would be obligated to go underneath the polluter pay principle after the bad actors in its state. So in this case, they would want to settle the case for as low as possible. And what would that do? That would in fact hurt the citizens within that state, right, that are impacted by the harm, and also in the other state, okay? So I'm just putting that out there for kind of background, right? Next, the country that is suing and is talking about, or the state that is suing and is talking about the projected harm, okay, this is the hard part. Within their state, internal to other states, there's misinformation and disinformation about the climate crisis, right? And what that does is it causes states to not build their city correctly. So they don't use the right code, they don't use the right climate risk map, and in return, because they've built their city incorrectly, they aren't climate resilient to the rapidly changing climate, right? Should the other state bear damages, right, based on the fact that their own state didn't didn't enforce the law, right? And allowed for misinformation and disinformation to exist within that state. And then next, when it comes to determining penalties and damages, right, the parties that are harmed are not necessarily only the parties from that state. They're actually also the parties within the state that they're suing, because it's the tax dollars of the state that they're suing that is going to end up paying out that claim. So how should the penalties and regulations be calculated based on that? And then also thinking about future generations.
All right, I think this is enough for our first round of answers. Kenneth, can I ask you to go first? Sure. Let's see how far you get.
Sure, no problem. Yeah, exactly. I'll address your question first. So on Ecuador, first, just to take a step back. So Ecuador is not that they didn't request lost profits. They did, actually. They presented a DCF valuation. What happens at the tribunal, so it had been bifurcated on various stages. So on merits, the tribunal essentially said there's no expropriation, but there is FET. And then in damages asked for valuations based on that. Up until then, claimant had, as many times do, presented DCF valuations based on expropriation. In other words, complete decimation of its investment, right? And so he said, and they suggested that, please provide information about potential lost profits. So some percentage of that and how you get to that. Claimants didn't do that. Claimants presented, again, a valuation based on everything, yeah. So, and based on that, tribunal found, look, on FET, all you get is lost opportunity because you actually hadn't started operating. There was this issue about delimitation, about where they could mine in the Paramo. And because they didn't present a lost opportunity valuation for some subset of the entire value, there was no valuation. Yeah, but I know we have an expert who was actually probably involved in the case here, so feel free to jump in. And with respect to this, to what you were mentioning about the Spanish cases and the reasonable rate of return, I think that opens up the whole. And I had also wanted to address. I think it's been discussed here in the panel about the fact that I think. Valuation methodologies are now going to have to become much more, I guess, complex, right, and much more input. I mean, the truth is DCF valuation, I agree. I think for most, particularly ongoing businesses, it was an easy valuation methodology that one could understand conceptually. And so it was adopted by a lot of tribunals consistently. And it kind of became kind of the de rigueur methodology to the point where representing states oftentimes, like, it became DCF for everything, oftentimes when it's not appropriate, right? And so I think we're seeing that doesn't work, particularly in climate change disputes, right? Because now you really have to get into a lot of the weeds in terms of how you value something concretely, instead of just looking abstractly at income-based approach, which, by the way, because it's an adversarial nature, right? We all know this. The claimant's experts is always going to assume, rose. Everything is perfect. Respondents will not, and so you have that variance, which Lukas had mentioned, and is a big criticism often of DCF. I potentially think that, look, that's the system, and the tribunal has ways to mitigate that, either getting their own expert or kind of flushing out some of the issues. But there is, these different analysis, the impact assessments, the social cost benefit analysis, all of that's going to have to be part of the analysis. So, yeah, that's it. And on the second question, I mean, good comments, but I really don't have much to say about that. I don't know if my colleagues have.
Okay, Veronica, anything to respond to?
Yeah, I wanted to comment on two things. One, on the DCF, I think we have seen great, differences at times, but it often comes from the instructions that we receive as experts. So it's not the DCF method, it's the instructions on how you build the bot for what matters. So I do think that it's a really good and strong method, not for new projects or new technologies, but for established industries. And I also wanted to comment on the country risk. I really don't know if Damodaran has included that, but in my experience, that is also related with how you build a bot for. And you don't always have to include everything in the return. I think often it's more transparent to include it as part of the income and stated very clearly, you are including these environmental regulations, and that's how the income would change, or not, instead of just having like a fudge factor or something that is more obscure. I find that more direct.
If I could, I just want to add on the country risk and how to kind of implement that risk. And here your colleagues at Compass Lexecon are actually really good at RWE v. Netherlands. The report they give, they lay out kind of some of the other issues and costs that need to be taken into account when you do evaluation looking forward with respect to phase outs and environmental regulation. And one of the things they point out is that you could either address it by cutting off the cash flows, by reducing the cash flows, or by affecting the discount rate, which is not necessarily through country risk, but you can actually price out, the transition risk, right? And I think some banks are in fact doing it already, where there's going to be transition with foreseeable, and there's a method to kind of develop a coefficient that then gets plugged into the discount rate. So that's one way. And then the other thing they laid out is that in fact in RWE, they had mentioned that investment banks, when they were valuing RWE, only gave them a shorter time span than their DCF model was valuing at, because they saw that after a certain period of time, there was going to be a transition, right? So that's one of the things that I think arbitrators need to be aware of, right? And I think that, definitely opposing experts to be aware of what's going on in the analysis of the other side.
Let me see if Lukas or Fabricio has anything.
Can I respond? Yes. Yeah. Sorry. There, yeah. Very quickly to respond, especially to Miguel and to Veronica. I mean, your points are really well taken. I think my initial point was more about differentiating, obviously, between situations where you have a going concern, you have established, business track record, and these other cases, which are particularly relevant for the fossil fuel phase-out discussion, where you look at, very early stage investments. And there are all these governments now that are conducting foresight, exercises where they're trying to put a cost to the transition. So if you are advising, bearing this prevalent methods in mind, if you're advising a government that would like to phase out upstream extraction and knows that a large part of these investments are at a very early stage, how do you put a number to that if the currently prevalent method is discounted cash flow? That is a regulatory and policy question, which I think is the reason why some governments are introducing now this idea of saying we need some kind of guidance as to when that method may not be appropriate, as opposed to situations where you have a going concern and you have a track record. Yeah.
Oh, there you go. Thanks. I want to comment first on the country risk, which I think the issue has to do with the way that typically has been incorporated, which is sovereign spreads on sovereign debt. And the issue that we're talking here is a different risk, is the risk of environmental tightening, regulation tightening, the risk of all of those things that they need to be priced in. And it's not entirely clear that sovereign spreads pick that up. So that's the question, and it goes to the point that there's ways in which you can parcel that out in ways that it's more reflective of what is that you're trying to price in the country risk. If you're telling me that the investor is protected against expropriation, I'm not sure that sovereign spreads picks that up. Sovereign spreads pick that up, the risk of a country defaulting on dollar-denominated debt in international markets. It might be related, but it's not necessarily the risk that you're pricing. And second, that also incorporates potential, that assessment of risk that international markets do on sovereign debt might pick that up certain things that are potentially priced already in your cash flows. Inflation, devaluations, reserves crisis, and all of that. So it is not a direct relationship. second, I want to comment on the issue of the method. And again, not to pile on Lukas, but I think the methods is independent of what we're trying to do. And a discount cash flow model for this should capture expected returns. We can argue that within the expected path, there might be an incredible amount of volatility. And that creates an issue of how we pick that up in the modeling. But you know, the typical example is sort of early stage projects that might be speculative. Yes, but it's not the DCF. If I have very good ways of picking up the risks on a DCF model on an early stage project, what I will end up getting at is an expected value that is not different, say, to an option value. Options, you might be familiar with them. There's the option to do certain things. And if the project is truly very risky, with lots of uncertainties and lots of sort of milestones that increase the overall risk, well, you end up with a DCF is the option value. So it's not that an early stage model has to be optimistic. It doesn't have to be. And it's properly put together, you'll end up with an option value. And that's perfectly fine if that's what the project is in the market.
I'm just checking with Jose. Are we fine with the time still? I see two. Let's take two final questions. You'll keep it short. Yes.
Mine will be easy because it's very general. Thank you. And I think Kenneth already referred to this as a potential transition risk. And I was wondering whether indeed that was something that in the valuation industry, if I can call it that way, is something that is being considered. Because if I understood correctly, Fabricio's point, country risk might not be something that indeed can encapsulate or capture climate-related risks. And so I wonder whether the industry is thinking of creating or at least pushing or some way establishing the same way that country risk was set forth as one of the elements that need to be considered one of the elements to be considered in the analysis, do something similar but relating to climate changes specifically. And I guess in some instances it will be the risk of the regulation, the risk of the asset being affected by regulations because it knows that the transition will happen. But for other assets, it might be something more related to how nature will, like, I don't know, droughts or et cetera, might affect the asset. So whether that is something that is being discussed or could be developed and could help also in climate-related disputes.
Very good. Final question, please keep it short. The back of the room.
On the valuation side, just a quick question. How do you account for the growing demand for oil and gas through 2050 and beyond projected by IEA, OPEC, WoodMac, and others, which would move in the complete other direction of what you've been discussing so far? Thanks.
Fabricio, do you want to?
Sorry, I couldn't hear the question very well.
Sure. So how do you account in a valuation context for the growing demand for oil and gas through 2050 and beyond projected by OPEC, IEA, WoodMac, and others? Because that pulls in the opposite direction of the regulatory risk that you've been discussing so far. Thanks.
Well, you have to. There's no way around it. It will be, as economists, we usually try to go to market-based information. So, and with the geopolitical environment that we are now, we'll all become more familiar with futures and the price of oil and the curve and what's happening and all of that. And that's something that for us it's very, we're very familiar with that. The question then is, I cannot go blindly to say, well, there's futures curves that price long-term demand of oil and the market signal that it's giving me in terms of what the equilibrium price of oil might look like. The question is, what transition risk is priced in there? I cannot just say that is the transition risk that counsel will instruct me the counterfactual would be. Is whatever the market has in there, but not the risk. Now, that's a good starting point, for sure. It's better than coming up with my own in a room, because it's at least market evidence. But you have to take that into account, for sure.
Anyone else on the two final questions? Miguel?
Yeah, on the first point that you were asking if within the valuation industry, I think Kenneth made a reference to the RWE case. Yeah, I mean, banks, that's why we're always looking, as Fabricio said, for market evidence. There is a transition risk, and I want to use that with a grain of salt because it's not always a bad thing. If you are an investor in renewable energy asset, that's good for you, right? It's going to be more demand for, if you're a solar panel producer, for example, that the transition is a positive. I haven't seen something specifically like a country risk level. The country risk, so we're all on the same page, is always negative, right? It's something that increases the discount rate, reduces the value of the assets. I think in the transition area is more nuanced on a case-by-case basis, and that should allow us to incorporate in the valuation of the asset, but as Veronica said, in the cash flows, what that means for that particular asset. So it can be a phase out, cutting the projection, making it shorter. You cannot use the terminal value for this asset. Sorry, I mean, it's going to last the next 5, 10 years. That's it, right? And it's going to have, you can use a growth rate. It's going to go down, right? So in that sense, that's how we've been using it instead of like a country risk premium or a premium that you incorporate that is more like encompassing a lot of factors, not only this.
Yeah, and just to add to that, again, you have to be really careful not to double count on the cash flow and the discount rate. And sometimes, these risks are already part of the value. Like I was going to buy a house and it's in an area that is prone to floods. So if you look at the value of the house, it has gone down because the insurance company won't insure or it's really expensive. So sometimes these numbers are already factored in and therefore you don't need to add anything to the rate.